Hai, Assalamualaikum warahmatullahi wabarakatuh. My name is Latifah Rabbaaniah binti Jamaluddin. Today, I'm going to share with you about the truth behind the principles of advocacy and code decorum based on my readings and some of my little experience during my practicum day at the High Court of Shah Alam. So, let us see what is the truth behind the principles of advocacy and code decorum. It is easy on theory, but difficult in practice. To understand better, let's take a look what is the meaning of this phrase. According to Merriam-Webster, an online dictionary, the word advocacy is referring to an act where a person is speaking on behalf of somebody. Whereas the word court is referring to a place where the administration of justice takes place. And the word decorum is referring to a proper behavior that must bring in to the courtroom. From this definition, we can understand that this phrase is referring to the act that a lawyer must bring in to the court. They must treat everyone with courtesy and respect in the courtroom. However, this is not an easy practice. I'll tell you the reason. First, the very basic ethic at the court is that the lawyers must come early before the judge. So, most of the court in Malaysia will start their hearing sessions as early as 9 a.m. in the morning. It depends on the court. However, some lawyers could not make it on time, regardless their seniority. So, back then, when I was given a chance to join a sessions in an open court at the High Court of Shah Alam, there was one lawyer who had failed to come in late for 5 to 10 minutes. Fortunately, the judge did not mad, but I know this is quite embarrassing for that lawyer. So, dear future lawyer, it is good to come early before the judge. Now, the second reason is legal counsel should not oppose the other counsels or party, and this is a well-known fact, but it is only hard to apply. This is what I've seen during the sessions when a lawyer was presenting his or her client case. He was in a high spirit. So it becomes more challenging when a witness, for instance, act like he doesn't know what is the meaning of the question given by a legal counsel, or when the judge keep interrupting and reminding the legal counsels that they should not act like a fighter in a war. So they seems like having a hard time, but I know they also know about this ethic. It is only hard to apply. Now, the third reason is a legal counsel should only state their legal grounds in making objections. They cannot give further comment or additional argument. I think I have learned this thing during my college year when I was joining the debate, that it is simply hard to apply. And I think the same thing goes to the lawyers. Some of them tend to give additional comment and argument while concluding their case, and this is not necessary unless the judge asks for it. So, by giving an additional comment or argument while concluding your case, it shows that you have given a late detail in your previous statement. So this is not good. Bear in mind that most judges wanted a legal counsel to make a clear statement while making your case, so that everyone in the courtroom could understand the case better. Fourth and final reasons from me is most legal counsels tend to focus more on their case law as their authorities rather than to focus on the fact of the case. This can be seen through the thickness of their written submissions. Yes, it is indeed good, but however, according to the former Malaysian Chief Justice Tun Abdul Hamid, he said that he would prefer to understand and would be interested more to listen to counsels who understand better the fact of the case and the legal proceedings. So, not all lawyers could master in this area. As a conclusion, story told shows that the advocacy and code decorum is an easy technique to be taught. However, this is not an easy technique to be applied in the courtroom. Above all, it is depending on one individual's skills, style, and character. I think that's all from me. Thank you.